Okay, welcome back. We'll call us back to order, and I believe, Mr. Anthony, you're up.
Thank you, Mr. Chairman, members of the commission. Mr. Seaman Wynn, how you been?
Good, Mr. Anthony.
Haven't gotten a chance to spend time with you since we were kicked out of the Brunswick plant together, so
It's been a long time since then.
nice to see you. We'll tell you that story someday about what we did there. We're going to talk about CAMA and the environmental remediation costs that CAMA has imposed upon DEP. Okay. First, to set the context and the ground rules of this, the ORS does not dispute that it's prudent for DEP to comply with CAMA. We ought to obey the law, right?
I don't believe that that's in dispute.
Okay, just making sure that you're not suggesting that we should violate the law and pay penalties if that's a cheaper thing to do. You expect the utilities of this state to comply with what the law says.
We expect Duke Progress to abide by all state and federal laws.
So it's prudent to comply with the law.
Yes.
And I haven't seen anywhere where the ORS has taken issue with the cost that DEP is spending to comply with CAMA. We're not saying those costs are unjust and unreasonable.
That wasn't part of my review in this case. That could better be addressed by Mr. Whitliff.
I didn't hear Mr. Whitliff. I thought in response to questions from Mr. Burnett, you agreed that the costs that have been incurred are reasonable to comply with CAMA. Mr. Whitliff.
Mr. Chairman, Mr. Whitliff was available for questions from Mr. Burnett.
No, he was available for questions. I mean, they just said they were going to talk to either one of them. I mean, are we holding down who can talk to whom? This is cross-examination, so.
The record speaks for itself. That's
Okay.
what Mr. Whitliff said, and I'll rely upon it.
Okay, thank you.
Already in the transcript. Thank you. Unless Mr. Whitliff wants to disagree with what I just said.
No.
All right, thanks. All right, so that takes us to what I understand to be the fundamental basis for the ORS's recommendation that these CAMA-related costs be disallowed, and that being because that's a North Carolina law that calls those costs to be incurred, and the ORS doesn't see that South Carolinians are realizing any benefit from DEP incurring those environmental remediation costs. Is that right?
I don't believe that that's what is in my testimony. I believe what I said, testified to, is that South Carolina ratepayers should not be held responsible for the additional costs between CAMA and federal CCR.
And tell me why they shouldn't be held responsible for those CAMA costs.
North Carolina has invoked a law requiring additional costs for coal ash management and disposal that is beyond the requirements of the federal law. They have told the company that you have to do this. South Carolina ratepayers who have no vote for anyone in the North Carolina legislature are being subject to the additional costs from the legislature of another state. And that is not appropriate.
Okay, so just to be clear, is the ORS position that any time North Carolina passes a law that affects DEP or DEC's cost of service, if there's an incremental impact above and beyond the cost that would otherwise have been incurred, South Carolina should not be asked to pay for any of those costs?
Do you have any specific examples?
Well, we're talking about CAMA right now, and I'm just trying to understand whether the position you're taking with CAMA, which is a North Carolina law that imposes cost upon DEP beyond what would otherwise be required by federal law, and if I'm understanding you correctly, you say South Carolina should not be asked to pay for any of those incremental costs. Is that right? Did I accurately reflect your testimony?
You did.
Okay, and I'm simply asking for going forward purposes, is that a broad general principle that the ORS is going to apply, or is it more of a case-by-case basis
I would say that it's a case-by-case basis, but we do have past precedent from both North Carolina and South Carolina where jurisdictional costs have been allocated solely to within that jurisdiction.
So we'll focus here upon just the camel costs that you believe should not be allocated at all to South Carolina because they're passed by North Carolina, and am I correct, South Carolina is not benefiting from those costs?
I'm not sure what you mean by benefiting, but I don't believe that I addressed that within my testimony.
Well, then I'm confused because we've established that the costs were prudently incurred and they're reasonable. So once you cross those two thresholds, the only reason I can see why the ORS would say we the South Carolina portion of DEP's grid, should have to pay for any of those is if there's no benefit to South Carolina from DEP having incurred those costs. If that's not the reason, what is the reason that South Carolina should not be allocated any of those camel costs?
I believe I stated our position that South Carolinians should not have to pay for laws, incremental differences passed by laws in North Carolina where they do not have any say in the matter.
But what if the incremental cost is produces a benefit for South Carolina?
Are there any in this case? I know I'm not supposed to be asking you questions.
And I'm not going to answer them. But I'm completely befuddled because you and I have been doing this a long time, and if a utility cost is just, is prudent, is reasonable, then the utility's entitled to recover them. And I'm searching for what is that other element that the ORS is relying upon to disallow these costs. And what I'm hearing you say is simply because North Carolina passed a law that imposed these additional costs without any consideration of whether the incremental cost incurred benefited South Carolina or not. So help me understand what is the foundation of the ORS saying, no, these just and reasonable costs should not be allocated to South Carolina for recovery.
Mr. Chairman, this question has been asked and answered.
Just go ahead and answer this one time, and then we'll get it.
Thank you, because
we'll
I
move it
haven't
on, 'cause I haven't heard the answer yet.
I'm not sure what you're looking for, Mr. Anthony. I've stated ORS's position and why we feel that position is reasonable.
Would you just say one more time what that reason is?
It is ORS's position that South Carolina ratepayers should not have to pay for the incremental difference between the North Carolina state law and the federal law regarding coal ash management and disposal. Because South Carolinians do not have a vote for anyone within the North Carolina legislature.
Okay, well, we're going to come back to some benefits that we definitely need to discuss, but since you seem to be hanging your hat on the fact that, or the allegation that South Carolina did not have a vote, what is the state agency of South Carolina charged with representing the using and consuming public with regard to utility matters?
That would be the South Carolina Public Service Commission.
No, representing them, not making.
Pardon me, that would be the Office of Regulatory Staff.
And the Office of Regulatory Staff is empowered to intervene in other states' utilities commissions proceedings, are they not?
Yes, we are.
And you've done that in the past.
We have.
So, and there's nothing to stop the ORS from engaging a lobbyist to participate in the legislative process in North Carolina, is there?
Objection, Mr. Chairman. The ORS cannot engage lobbyists.
Is there anything that prohibits the ORS from expressing its position to the North Carolina General Assembly?
I can't speak to that.
Okay. So to the extent in the North Carolina Utilities Commission rate case where they address the issue of allocating these CAMA costs to South Carolina, South Carolina could have participated in that proceeding, could it not?
They could, but I believe in the North Carolina proceeding, the North Carolina Commission allocated North Carolina's costs.
And they also held that the the portion that was not allocated to North Carolina should be allocated to South Carolina, didn't it?
I can't speak to that other than to say that allocations are divided amongst various jurisdictions. North Carolina Commission did that.
Okay.
They are responsible for allocating the cost to their consumers.
To the extent South Carolina was not represented in that Utilities Commission proceeding, that falls on the ORS for not choosing to participate in that proceeding. Isn't that right?
Yes.
Now, these prudent and reasonable costs associated with CAMA compliance are associated with plants, coal-burning plants, some of which have been in service for decades, 40 to 70 years, right?
Yes.
And those coal-burning plants have provided 3 separate benefits to South Carolina during their operating life, haven't they? Number 1, the electricity.
Yes.
Number 2, by building those plants in North Carolina, South Carolina didn't have its air quality impacted, its water quality impacted, land cleared, ash ponds built and filled up. South Carolina avoided having any of that impact to its environment by the plants being located in North Carolina, did it not?
There are plants in North Carolina that do have an effect on the water in the rivers and the streams in South Carolina. So I would disagree with that statement.
Well, the environmental impact of building and operating a coal plant in North Carolina is much greater than the impact if it were located in South Carolina. I said that in reverse. The environmental impact of a coal plant located in North Carolina is much less than the impact it would be if that same plant was located in South Carolina, from an environmental impact to South Carolina.
Mr. Chairman, this was not only asked and answered a second ago, it's also well beyond the scope of what Mr. Seaman Wynn testified to in this proceeding.
Mr. Seaman is the policy witness here, and my purpose here is to show there's tremendous benefit that South Carolina has reaped for decades from these plants, and if he's not the right person to talk, they need to find a witness who can, because he's the policy witness on this issue.
Overruled. Continue.
You please restate the question.
The fact that these coal plants that are subject to CAMA, whose costs you do not want allocated to South Carolina, the fact they were located in North Carolina, the environmental impact, the vast majority of the environmental impact associated with building and operating a coal plant has been burdened on North Carolina, but yet South Carolina has been able to enjoy the electricity they produce, right?
For the most part, yes.
Well, at the most part, they didn't get the ash ponds that we're now having to remediate. South Carolina avoided having the ash ponds because they were located in North Carolina where the plants are.
I would say yes to that.
And the third benefit is by CP&L, I'm sorry, I've been CP&L for so long it just comes out. The third aspect of this for DEP and the benefit to South Carolina from these plants being located in North Carolina is CP&L, Progress Energy, DEP, plans their system to serve both North and South Carolina in the aggregate, do they not?
They do.
And by having that larger footprint and more customers, they enjoy economies of scale and scope in just about every arena, whether it's dispatching plants or buying coal or arranging for freight. Isn't there a benefit to that?
Yes.
And so if DEP was forced to start separating its system because of the refusal of South Carolina to pay its fair share of the cost and start serving a North Carolina system and a South Carolina system, that would drive up the cost of providing service, wouldn't it?
I can't speak to that. DEP's only plants in South Carolina are both nuclear and natural gas fired.
Yes. But in order to build, South Carolina is only about, 15% of DEP's entire system?
11 to 13% is the figure I'm familiar with.
All right. So if DEP were to attempt to build just a South Carolina system, rather than a system in the aggregate, it would lose the economies of scale and scope that come with building a system that is designed to serve both North and South Carolina.
It would, but we're not suggesting that.
That's a benefit from having those plants in North Carolina and part of an overall system.
Yes.
Now, Mr. Chairman, I'm going to ask Mr. Seaman Wynn a question that requires me to set up a hypothetical, and I got to run through a few preliminary matters to set the context, if you'll bear with me. Mr. Seaman Wynn, if you would imagine that Commissioner Howard and Hamilton own farmland out in Marlborough County, and they're side-by-side neighbors, and they farm. And one day, Commissioner Howard says to Commissioner Hamilton, you know, we got these two pieces of land right beside each other. Now, I failed to mention Commissioner Howard's land is only about a third of Commissioner Hamilton's size of his lot. So his farmland is only about a third as big as Commissioner Hamilton's. But they get together and say, you know, it'd be a lot more efficient if we farmed our land together. We bought equipment together and irrigation equipment together and ran this thing together. We could enjoy some of those economies of scale and scope that I mentioned a while ago. Okay? And they look around and go, we need a place to put trash and other debris. And there's no reason to have two of those. Why don't we just have one? And Commissioner Hamilton, being the magnanimous person that he is, says, I got the perfect spot. You just bring all your stuff, and I'll put all my stuff, and we're going to put all this debris and waste over here in this big old trash pit we'll dig. And decades go by. And they put tires and creosote poles and egg cartons and used oil and everything else in the world into that trash pit. And lo and behold, one day, Commissioner Hamilton's wife actually visits the farm. And she says, my goodness gracious, what a mess you got back there. You got to clean that up. You got to haul off all that waste and debris and used oil, and I want a nice garden bed planted out there. And it cost poor old Commissioner Hamilton $10,000 to clean up that big old trash pit. And he goes to Commissioner Howard and says, you know, neighbor, you've been benefiting from this for decades. How about ponying up half the cost of me having to clean that up? And Commissioner Howard says, not me. I didn't benefit from you having to clean up that spot and put your garden bed in to satisfy your wife. I ain't paying anything. What's your reaction to that? Is Commissioner Howard doing the right thing?
Mr. Chairman, I would object on this. I appreciate the hypothetical, but there were so many facts. It was so convoluted. To be honest, it was difficult to follow exactly the different facets that are going on in the hypothetical.
Overruled. I was following it pretty good. I want to hear the answer.
So which one of them is in the right? Commissioner Hamilton or Commissioner Howard whether Howard should have to pay $5,000 towards that $10,000 remediation cost?
It's an interesting hypothetical, Mr. Anthony, I have to say, and I hesitate to answer because I don't want to disadvantage either of the commissioners. I think that your hypothetical leaves a lot of factors out that are points in this case. I think it may be more appropriate to suggest that instead of Commissioner Hamilton's, Commissioner Howard's farmland both be in Marlborough County, that one commissioner's land was in Marlborough County and the other commissioner's land was in a conjoining county. And that is one county that says that you have to clean it up. Hypothetical of using Commissioner Hamilton's wife isn't appropriate in this case, I don't think.
Well, let's use your hypothetical. Let's assume that they are right on the border, and Commissioner their lands adjoin right on the border between the two counties, and Commissioner Hamilton is in Marlborough, and I can't name a county right next to it. Is it Dillon? What's next to Marlborough? Robinson over there. Same fact situation, except instead of Commissioner Hamilton's wife laying down the law. It's Marlboro County laying down the law. And Commissioner Hamilton has to clean up that trash pit and return it to pristine condition. And he goes to Commissioner Howard and says, how about $5,000 to help me pay for this? And he says, no, 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 no. That's your problem. You're stupid enough to have located in Marlboro County. I ain't paying. Is that right? Is that a fair way to treat people?
Mirroring your hypothetical compared to the situation that we're in right now, yes.
I don't have any other questions.
Thank you. Commissioners. Commissioner Howard.
Mr. Chairman, I have one question, and it's not a hypothetical. You're suggesting 25% of the revenue to be allocated for the fixed cost, basic facility charge, correct?
For the residential, small general service, and small general service constant load classes, yes, Commissioner.
Let me give you my mindset. My mindset is you and Miss Edwards and Mr. Bateman all sitting up in a conference room at ORS saying, what are we going to do? And then you pull 25% out of there. How do you justify a number? Had you said 23 and a half or something, I might have said that makes sense. But just pull up 25%. You understand where I'm coming from?
I do, Commissioner, and let me say that the starting position, our starting position when looking at the basic facilities charges, we had the advantage of having Duke Energy Progress and Duke Energy Carolinas having just completed rate cases in North Carolina. So one of the things that we did was take a look at all of the public testimony and the commission orders within those North Carolina dockets. One of the things, Duke Energy Carolinas used the minimum system method for designing its basic facilities charges in North Carolina. And the North Carolina public staff took issue with the magnitude of the basic facilities charge for the residential class in North Carolina. Excuse me. The public staff witness up there recommended using 25% of the additional revenue requirement go towards the basic facilities charge. We looked at the analysis of North Carolina staff. We then, with that in mind, we then looked at the revenue requirement for South Carolina ratepayers and allocated that down to the residential class as well as all of the other classes. We looked at 25%. We looked at other percentages as well, in line with the ORS recommended revenue requirement. And we settled on a 25% of the revenue requirement go towards the BFC for not just the residential class, the way that the North Carolina public staff recommended, but also for small general service class and the small general service constant load class. We looked at other percentages besides 25%, but 25% seemed reasonable, and that is our recommendation.
Thank you. Commissioner Belser.
Thank you, Mr. Chairman. Good afternoon.
Good afternoon.
Mr. Seaman Wynn, how are you today?
Well, thank you.
I'm looking at your Sir Rebuttal Exhibit 5, MSH5. It's the average monthly residential bill comparison of
Yes,
1,000
Commissioner.
kilowatts. Has ORS calculated energy charges with regard to its recommendation on rates?
We have not.
Okay, then how did you come up with this comparison if you haven't calculated energy charges?
If you take a look at my Sir Rebuttal Exhibit MSH1, in column column D shows the ORS proposed revenue increase for each percentage for each class, not including the EDIT rider. You'll see for the residential class that is a 7.33% increase. We took the currently approved typical residential bill, which on my exhibit, surrebuttal exhibit MSH5 is $122.49, and increased it by that 7.33% to come up with a base total. We then, and that would correspond with the $131.46 on my surrebuttal exhibit MSH5. The difference between the $131.46 and the $121.20 is the inclusion of the EDIT rider.
Did you check back, run that back through to make sure that that covered the revenue requirement that y'all had calculated through ORS's adjustments?
Yes, Commissioner. If you, again, take a look at my exhibit MSH1, surrebuttal MSH1, and looking at column C, you can see that the revenue requirement for each class totals up at the bottom to $32,130,000, which is ORS's recommended revenue requirement in this case. Additional revenue requirement.
Okay. Thank you very much.
Yes, ma'am.
That's all I have.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. Got a couple of questions for each of you, and they're pretty basic, but I'm going to kind of go back and forth between the two of you. I guess, Mr. Seaman Wynn, I guess I'll start with you. You had an exchange with Commissioner Howard about the determining the 25% increase from the BFC. In your testimony, and you said it again here on the stand today, you say that it's not really ORS. I just want to be clear. You say it's not really ORS's position. That's just what the company agreed to. Is that what you're still stating? Am I understanding you right? In other words,
Yes, Commissioner.
ORS isn't necessarily in agreement to it. You're just stating that's what the company has agreed to. I'm talking about the $11.78 for residential for basic facilities charge.
Yes, Commissioner.
Okay, so as I asked the other witness, ORS is still not staking that out as their position.
I think it is a good starting position, Commissioner. That is the basic facility charge using the methodology that I am recommending to this commission, and it's also based off of ORS's revenue requirement. Should that revenue requirement change, should the commission approve something different than what ORS has recommended to the commission, then we would look at the methodology that we had used and, if necessary, make an additional recommendation to the commission.
Okay, I was hoping you'd say something when you were hesitating there. I'll ask you like I asked the other witness. Do you have a number? Do you have another number? Does ORS have another number in mind for BFC?
No, Commissioner, we don't.
Okay, hold that thought just a minute. I want to go to Mr. Whitliff just a minute. Mr. Whitliff, this is just as basic as it gets. Can you turn to your chart, table 5.4?
Yes, sir.
Give you a second to get there. You had it on the screen earlier.
Yes, sir.
If you could give me a location on these plants, I know what's in South Carolina, but if you could give me a general location of the North Carolina plants.
Asheville is in southeast North Carolina, just across. It's about 12 miles inside the border from South Carolina. I mean, I'll tell you what, I've got a.
I don't think so, but
No, give me a second here. I've got I can actually describe it now that I have a map here in front of me. Asheville is at roughly the intersection of Interstate 40 and trying to see.
26.
Yeah, there you go, sir.
Tell you what, Mr. Whitliff, how about I read, there's one or two I'm unsure of. Let me read what I got, and then you add to it if you know.
Yes, sir.
Weatherspoon, is that fair to say Lumberton, North Carolina area?
That is, sir.
Sutton, is that fair to say Wilmington area?
Yes, sir.
Roxborough, is that fair to say a little north of Raleigh?
Yes, sir.
Mayo, up near the Virginia line and also north of Raleigh, is that fair?
It's about 10 miles north and east of Roxborough.
Correct, okay. Cape Fear, Wilmington area.
Cape Fear is, let me find it on my map here. Cape Fear is south of Raleigh.
Okay, and Asheville area. Help me out with the H.F. Lee.
H.F. Lee is...
That's the one in where there's a wide disparity. Help me out with that location of that one.
I'm trying to remember the town that it's close to, but it's north of Witherspoon. Just trying to remember the town that it's near. I've got that on some other places, but it's in that general area, north of Witherspoon.
Okay. I think I've got a handle, and of course Robinson's in South Carolina.
Yes, sir.
Talk to me about the, of course there been demonstrated here today, large disputes between the amount requested and the amount that ORS proposes, right?
Yes, sir.
And this kind of boils down to the dispute over Camel and dispute as was just demonstrated again in another exchange here by Mr. Anthony. What I want to ask you goes back to, I guess, an exchange with Mr. Elliott a little earlier. Once you start down this path, you're complying with federal CCR regs, you're complying with CAMA, and then you're complying with a consent order here in South Carolina with DHEC. Once you head down this path, Mr. Elliott had a something up on the screen that showed an astronomical number. I guess my question is to you, since you're the environmental witness, where does it end? The cost. Where, in your mind, Mr. Elliott put a staggering number up there. And I know that's not in this case, but where, for the ratepayer, where does it end? And you, as an environmental expert, I want to ask you that question. Are you seeing those staggering billions of dollars that he put up there? Where do you think, is there an end in sight?
Commissioner, in anticipation that this question might come up with regard to, I'm presupposing that the DEQ decisions in North Carolina kind of drive this discussion. And we did some analysis, just, I wouldn't say it's exhaustive or extensive. And we took the lowest value that we had from known offsite disposal, and we applied that to the different plants involved. We also took the lowest value that we had for on-site landfilling, and it depends on what is an acceptable alternative, or let's even call it a doable alternative at each one of these facilities. And using those very conservative numbers, our assessment system-wide, now admittedly these are big numbers to begin with, but our estimate is that the cost could increase with on-site landfilling be for the lowest cost that we had available. That would be somewhere in the ballpark of a $2 million adder, $2 billion adder to the cost that we have currently being asked for. Then, I'm sorry, the total project cost, I apologize, for these 6 sites, just the 6 sites. And if we take that low value for off-site hauling, dollars per ton, we apply them to it, and we get somewhere close to $5 billion adder. Now, those could double beyond that even. If the unit cost that we used was $83.41 a ton, and that's based on W.S. Lee. If we use the Dan River cost per ton, that number is $162.43 a ton. So you can see that if those unit costs are closer to the 162 than they are the 83, the cost could conceivably come close to doubling even more. So when you ask me, is there an end in sight, the number that we have that's very conservative says the impacts of off-site landfilling at each one of these 6 sites could cost the system another $5 billion.
Commissioner, if I could add
Yes,
to that.
please.
You ask where it's going to end. It ends for the ratepayer where this commission says that it ends.
Okay, and I was going to direct this to Mr. Whitliff, but either one of you, what do you think I'm trying to not be speculative, but this is going to call for speculation. What do you think the probability of the two of you or somebody for ORS sitting back here on the witness stand in a few years with another rate case with the company asking for another large amount? Where does it end? That's what I'm trying to get to. And I was asking him because he's the environmental witness, but either one of you can answer it. It's fine with me.
Okay. It depends on what they find as they go into these sites and they start doing it. I mean, the point being, these are very conservative estimates. They could go up from here. They could conceivably be on the $2 billion adder if they can do on-site landfilling everywhere. But the point being, I don't think there is. If you have laws that change and you have to go do something to fix it later, that's always been sort of the issue with environmental compliance. As the companies pointed out, as the laws change, they've got to comply. So the question is, does North Carolina stop at this point, or are there more coming? Is there more coming? And don't have a crystal ball at this point.
Well, I guess that's kind of where I was going. Does North Carolina's camel laws, does that kind of sort of end it, if you will?
Well, I think Dr. Wright pointed out yesterday, and I'm not trying to quote him, I'm just trying to paraphrase what I understood him to say. As he said, North Carolina has always been on the forefront of environmental pristineness. He talked about the Skylines Act, talked about the Clean Smokestack Act, talked about the Clean Beaches Act. The state has had a very progressive attitude towards the environment. They've got a beautiful state. It's pretty, and they want to keep it that way. I can certainly understand their motivation for doing the things they think are necessary to do that. The question is, where does it stop? And, you know, they think that that's what Dr. Wright was talking about, is that it may not.
Well, would you agree that that puts this commission in quite a predicament? And I'm going to ask you one more question, Mr. Whitliff. I don't think there was some debate about whether Mr. Anthony could question you or not, but in his exchange with Mr. Seaman Wynn, he talked about the benefits of South Carolina ratepayers for joint dispatch, fuel savings, and some of those things I guess he's referring to from the merger. If the ratepayers benefited from those things and benefited from generation for these decades and decades and decades, then don't you see that this commission's in quite a predicament here? What would you do if you were sitting up here?
Well, I'm not, and
True.
And to be quite frank, I'm kind of glad I'm not, because
We've heard that before.
Sure you have, because what y'all have here is a really tough job. On the one hand, you've got to balance the needs of the community, and you've got to balance the needs of the company to continue as a viable entity, to make sure that they're not being unnecessarily punished for doing what they feel is the right thing. Those are huge responsibilities to carry out. The question that I see that the commission has in front of it is it the will of the commission that there has to be some sort of working relationship between the commissions in the two states? I mean, obviously, allocations are being made by one for the other. And so it seems to me that this would be an issue where the commission, once you make your decision here, that perhaps, I'm not trying to tell you what to do because that ain't my job, but at the same time, I think it might be worth the trouble to get together and see if y'all can come to a meeting of the minds, because this could go on a while. I mean, environmental rules have a way of ratcheting up and up and up. I've been in this business since '81, and I've seen nothing but that. So it could go even more ratcheting. So, and the cost would go up. So the question is, at what point does this commission say, we've got to figure out a way to get at least a handle on this going forward? And I think that getting together with the North Carolina Commission and talking about your mutual areas of concern might be a really good first step. I don't know if y'all do that already.
We know them very well, but we're limited
Okay.
in what we can discuss. And I guess what I want to ask you, your testimony is that this occurred over decades and decades and decades. We didn't get in this overnight, and you're saying we're not going to get out of it overnight.
Yes, sir.
Thank you. That's all I have, Mr. Chairman.
Thank you. Any other questions? Commissioner Urban.
Thank you, Mr. Chairman. So to hear your cost estimate there that you spoke of earlier, did you say 186 per ton? Is that for the
high end?
Yes, sir.
The high end is $162.
162.
Yes, sir.
Okay. Was that the most recent?
Yes, sir. These are numbers that I had run based on the cost that we saw.
Right. And does CAMA require excavation?
It does for everything but the low risk sites, and that would be, in this case, Mayo and Roxborough.
So the bulk of it's going to have to be excavated.
Yes, sir.
What percentage?
Let's see here. I'm not sure that I want to do math.
Well, that's all right.
Like we talked,
That's all right.
but it's quite a bit. Quite a bit. It's well over half.
And excavation and transportation is more costly,
Yes, sir.
much more costly.
If you're transporting it off-site to a landfill distant, in some cases, the hauls are, well, let's see here. One is 60 miles, another is 70 miles, but there's several that are 140, 150 miles each way.
And you haven't even factored in an inflation rate, have you?
No, sir.
Or cost of fuel,
No, sir. No, it's just basically
cost of labor. None of that's been added in.
no, it's all included, but it's not like I escalated them up.
Right. And over what period of time?
Well, if you're hauling it off-site, depends on whether you're hauling it off-site with a unit train, which is generally 100 cars, 100 tons per car. That's 10,000 tons per train. Or if you're hauling it by tractor trailer, which is in the ballpark of 20, I think I used 22, 23 tons of material per haul. I think this goes to Commissioner Whitfield's comment in the DEC case about, how many trucks and how does that work? It's a lot. It's, in fact, in one case, I just ran a number on 1 million tons, just 1 million tons, not 56 million tons at the 4 DEC sites or 25 million ton at the 2. 1 million tons it'll generate on a 24/7 basis, 3 truckloads going down the road every 2 hours. And that's some chainsaw math. That's a friend of mine uses that term chainsaw, meaning it's real rough. But I'm going to tell you there's a lot of cities that do not want that coming down their street.
That's 24 hours a day, 7 days a week?
24/7.
And for how many years?
So for 1 million tons, that's roughly hold on a minute. I did the calculation, might as well make use of it. Where did I put it? There you go. There you go, right here. So over 3 years, it would take 38 to 41 truckloads per day, or about 3 truckloads every 2 hours, 24/7.
That's just for 1 million tons.
Just for 1 million tons.
And we're talking about an aggregate of how many tons?
For the DEP plants, what I'm showing is 25 to 26 million. And at the DEC 4 sites, that would be 56 million.
Thanks, sir.
Thank you, Commissioners. Any other questions? Okay, any redirect?
Yes, Mr. Chairman, I'll work to keep it brief. Mr. Chairman, if I could, I'd like to start off with a question from a commissioner and an answer given by Mr. Whitliff. This is South Carolina Code Section 58-27-170. I wasn't sure. Mr. Whitliff, can you read what that says there? I can try to zoom in a little more if I need to.
Do you want me to read it aloud?
Yes, sir, if you could.
The Commission may hold joint hearings and issue joint or concurrent orders in conjunction or concurrence with any official board or commission of any state or of the United States. The Office of Regulatory Staff may make joint investigations with any official board or commission of any state or of the United States.
Thank you, Mr. Whitliff. And I do have a few questions in addition to asking you to read that. Mr. Whitliff, was your role to evaluate the reasonableness of CAMA?
No.
How was your charge in North Carolina different than your charge in South Carolina?
In North Carolina, we were charged with determining the reasonableness and prudency of the actions taken by Duke up to the time that CAMA became law.
And how does that relate to what you specifically did in South Carolina?
In South Carolina, the primary charge, in fact, our primary mission from the very beginning was to determine quantitatively what were the marginal increases in cost brought by CAMA and subsequent amendments above and beyond what the federal CCR rules require.
And is your calculation here reliable?
Yes, sir.
Why are you comfortable with your methodology performed in this proceeding before the commission today?
In this case, we had an additional year's worth of data. I've been looking at this for 2 years and believe that we were able to come to some reasoned conclusions about what the data told us. In the North Carolina case, money was not the primary motivation. In fact, that whole discourse there that was highlighted in the North Carolina transcript was relating to a question from a commissioner who basically wanted to know, did we, instinctively we were telling, not instinctively, but we were telling subjectively there were differences. There were cost increases. If you change the options, it's going to cost more to do this compared to that, compared to this, compared to that. So as you got more complex with the solutions, they cost a great deal more. And we provided that qualitative analysis, but it wasn't our charge to develop hard numbers. We made a run at it, but the weighted averaging, it wasn't the problem. The problem was that we were dealing with budgetary estimates and did not have enough data to make what I felt was a sound conclusion. I don't think weight averaging is a questionable methodology in most parts. And all we were using it for was trying to figure out how much of the claimed cost were engineering and planning for sites that were not covered. Were doing construction during the period that we understood was going to be simultaneous engineering and planning across the system. And so it was just our way of levelizing those costs, trying to figure out what's a good estimate or good calculation for that. Weight averaging is an accepted methodology. The reason that weighted averaging wouldn't work there is we just didn't have enough data points, and we weren't comparing apples to apples. We were having some sites only had one or two options, maybe one only. Others, there are only one or two sites that had all four options for closure considered, so you had an apples to apples basis for comparing.
So am I correct that this Exhibit 63, of which a portion of it is now shown on the Elmo, is not applicable in this situation?
I don't believe so.
Mr. Whitliff, did your personal opinions impact your objective analysis?
Not at all.
Does CCR require beneficiation?
No.
Then it would follow that there are no savings associated with beneficiation that are required under the CCR rule, correct?
That's correct.
Mr. Whitliff, what closure method does the CCR rule require for Cape Fear?
It doesn't.
And Mr. Whitliff, how many people worked with you on this proceeding and the previous DEC proceeding?
I'm sorry. And can you be more specific?
Sure. How many people worked with you in GDS in reviewing the data provided by the company in this proceeding and the DEC proceeding?
There were 3, and one time we had 4 looking at the data. It was a lot of data to look at.
Do you know about how many pages of material you reviewed?
There was a lot. I got to say that I think you can see some of those documents over there. We probably looked at about 6 inches worth of stack of papers if you were looking at an equivalent stack. I guess that's about 1,500 pages, maybe more.
Okay, and to be clear, Mr. Whitliff, there's no evidence in this record to support the conclusory statements outlined in AAR 1-95?
Thank you.
I'm not sure if you can see that, Mr. Whitliff.
Okay, is this the one where we're talking about? Oh, please kind of zoom in on it.
I sure
you?
can.
Okay, this is the one where we're talking about the different plants. Excuse me. Earlier, when this was presented, I got to admit this was the first time I'd seen this, and I believe that the testimony provided by Karen didn't include this. I can certainly understand why someone would say, "Well, we provided this in discovery. You should have seen this," but it wasn't presented with the testimony, and so that's what my statement is based on. Not that it was never provided, because had I seen this, I'd probably have modified that somewhat, but that it wasn't provided with the testimony.
Okay. And Mr. Seaman-Wynn, I've got just a few questions for you. Let's see. I asked Dr. Roof earlier a question about the rate making being an art and a science. Would you agree with me that it is both an art and a science?
Absolutely.
Can ORS as a state agency employ lobbyists?
Not to my knowledge, no.
Could ORS employ a lobbyist to lobby the North Carolina General Assembly?
I don't believe so.
Is it administratively easier to return the tax savings via a volumetric charge? This relates to the BFC.
Yes, and I feel that it's more appropriate.
And finally, Mr. Seaman-Wynn, is it reasonable for South Carolina customers to pay disposal costs required by the North Carolina General Assembly that exceed the costs imposed by federal law?
No.
Thank you so much.
Thank you. Recross.
Thank you, Mr. Chairman. Only a handful. Mr. Whitliff, the couple of commissioners asked you questions about the recent North Carolina DEQ order. You recall that?
Yes, sir.
Are you also aware that the company has announced that it will appeal that North Carolina DEQ order?
Yes, sir.
And some of the testimony you gave responding to commissioner questions today illustrate why it might even be, in fact, impossible to comply with some of the things that DEQ has asked the company to do, like rolling trucks 24/7 for 3 years just for a single ton. Isn't that right?
A single million
A
tons.
single million tons, right?
Yes, sir. I can understand that.
And you would understand that when I get done here and go back to Charlotte with my colleagues, we're going to be working on developing arguments just like that for our appeal. Isn't that right?
Well, I'm going to say yes.
Yeah. And if we're successful in appealing that order, it may not be worth the paper it is written on. Would you agree with that?
If you're successful, the way that it read to me was a determination. I didn't see the word order in it, but I can understand why you might take it that way.
That's right. So it could come to pass to Commissioner Whitfield's question, that this could be over as soon as that appeal's over. Isn't that right?
It could.
Okay, thank you. That's all I have.
Thank you. All right. I want to thank you, gentlemen, for your testimony, and you may step down and be excused.
Oh, good. A break.
Okay, let's go with the next panel.
Mr. Chairman, may I briefly take up one matter?
Certainly.
I can take this up while we get the other panel moving. So
Okay,
kind of
get them moving and let's do that.
Yeah,
let's do
so
that.
two things at the same time. So my folks will be getting out the placards and getting everybody set up and getting out the summaries, I hope. All right. Mr. Chairman, Mr. Vice Chairman, members of the commission, the company and ORS have worked on compromise on certain accounting adjustments. It's a narrow set of accounting adjustments, and I was going to take a few minutes and outline that agreement in principle, if that would be okay with you.
Certainly.
Earlier, we did hand out a draft of that stipulation to the other parties, the other interveners in this case, so that they would have an opportunity to review it before this panel came up. And the panel in question that this affects is in fact the accounting witnesses. So with just a few minutes, we basically went through, if you recall, the issue about the storm costs. It's adjustment number 22. And I'm not going to go into detail on every single item. I'm just going to name the items that we've come to a compromise on. That's adjustment 22, the storm costs. Adjustment 28, credit card fees. Adjustment 25, which is rate case expenses. Adjustment 15, which is end-of-life nuclear reserve fund. And adjustment 39, which is the nuclear materials and inventory supply. And adjustment 21, which is the inflation adjustment to non-labor O&M. So at this time, we just have a draft and an agreement in principle, but it would be the intent of the company and ORS to execute this stipulation later today and hopefully get it e-filed by close of business.
Okay.
And Ms. Smith may want to add any words to.
I will add that my cross-examination has been greatly reduced.
That's always a good add.
I'm sorry, I did not hear the question. Oh, okay. Copies of the summary.
Ms. Edwards, what if we can on these? Let's get all of their for both of them, all of their stuff entered and see where we are, and we may take a break and then continue on with them.
So would you like me just to get their stuff in the record?
Yeah, let's go ahead.
Not have them go through their summary.
Right. Let's just get all that in the record first and see where we are then.
Okay, yes, sir. We can absolutely do that. All right, well, Mr. Major, please state your full name for the record.
Let's get that microphone on. There you go. You're on.
My name is Kelvin Leonard Major.
Okay, and are you the same Kelvin Major who pre-filed 17 pages of direct testimony in docket 2018-318E on March 4th?
I am.
Do you have any edits, changes, or corrections to your pre-filed direct testimony?
No, I do not.
Okay. If I asked you the same questions today, would your answers be the same?
Yes, they would.
Okay. And at this time, ORS asks that the pre-filed direct testimony of Mr. Major be read into the record as if given orally from the stand.
Mr. Major's pre-filed direct testimony will be entered into the record as though given orally from the stand.
Mr. Major, did you also pre-file exhibits KLM1 through KLM8 as an attachment to your direct pre-filed testimony?
Yes, I did.
Do you have any corrections to those exhibits?
No, I do not.
Okay. At this time, ORS asks that the pre-filed direct testimony exhibits KLM1 through 8 be entered into the record as the next hearing, be marked and entered into the record as the next hearing exhibit.
Mr. Major's exhibits KLM 1 through 8 will be entered into the record as hearing exhibit 64.
Okay, thank you. Now, are you the same Kelvin Major who pre-filed 15 pages of surrebuttal testimony on March 25th?
Yes, I am.
And do you have any edits, changes, corrections to that pre-filed testimony?
No, I do not.
If I asked you the same questions, would your answers be the same?
Yes, they would.
At this time, ORS asks that the pre-filed surrebuttal testimony of Mr. Kelvin Major be read into the record as if given orally from the stand.
Mr. Major's surrebuttal testimony will be entered into the record as though given orally from the stand.
Now, Mr. Major, did you file surrebuttal exhibits KLM 1 through KLM 9 as attachments to your surrebuttal testimony?
Yes, I did.
Mr. Chairman, KLM 9 was originally filed as confidential at the request of the company, but subsequently the company has withdrawn that claim of confidential treatment. ORS did file KLM 9 publicly with the commission in advance of this hearing. Of course, we have those exhibits to give to the court reporter today. Do you have any edits or corrections to your pre-filed surrebuttal testimony exhibits?
No, I do not.
Okay. ORS asks that the pre-filed surrebuttal testimony exhibits KLM 1 through 9 be marked and entered into the record as the next hearing exhibit.
Mr. Major's surrebuttal exhibits KLM 1 through 9 will be entered as exhibit number 65.
Consistent with your request, Mr. Chairman, I'm going to turn to Mr. Zach Payne.
Thank you.
At this time. Let's see. Mr. Payne, please state your name for the record.
My name is Zachary Payne.
All right. And are you the same Zach Payne who pre-filed 16 pages of direct testimony in docket 2018-318E on March 4th, 2019?
Yes, I am.
Do you have any edits, changes, or corrections to your pre-filed direct testimony?
Yes, I do. We had an errata sheet that we filed to that effect.
Okay. And Mr. Chairman, Commissioners, we also pre-filed redacted testimony reflecting those edits, those corrections as well, along with the errata sheet. Do those edits impact your recommendations?
No, they do not.
Okay, aside from those edits or corrections identified on the errata sheet and in the revised or the red line testimony that was pre-filed with the commission, would you answer the same questions? Would your answers be the same?
Yes, they would.
At this time, ORS asks that the corrected pre-filed direct testimony of Mr. Zach Payne be read into the record as if given orally from the stand.
Mr. Payne's corrected pre-filed direct testimony will be entered into the record as though given orally from the stand.
Are you the same Zach Payne who pre-filed 12 pages of surrebuttal testimony?
Yes, I am.
And do you have any changes, corrections to your pre-filed surrebuttal testimony?
Yes, I have one.
Can you provide that correction at this time?
Yes, on page 7, line 11, there's a footnote reference number 1. That should be removed, and accordingly, the footnote citation at the bottom of page 7 of my surrebuttal testimony should also be removed.
Okay. Does this change or correction impact your recommendation?
No, it does not.
Okay. aside from the edit or corrections that you just identified, if I asked you the same questions, would your answers be the same?
Yes, they would.
Okay. ORS requests that the pre-filed surrebuttal testimony of Mr. Payne be read into the record as corrected, as if given orally from the stand.
Mr. Payne's pre-file corrected surrebuttal testimony will be entered into the record as though given orally from the stand.
Mr. Chairman, that concludes where we are, short of providing the summaries.
Thank you. Thank you. Okay, we're going to take a 10-minute break, and then we will commence with the summaries.